Yes, Mr. Kramer.
My Lords, I'm here with Mr. Day and Ms. Edwards for the Bath Racecourse parties. Mr. Gruder and Ms. Higgs is here for Gatwick. And for the insurers, we have Mr. Scory, Mr. Walsh and Professor Davis over on this side. You should have a key documents bundle, a main with much longer bundle, and also, with apologies, a short supplementary bundle of authorities.
Yep.
You should also have had a timetable from us, although it's of course subject to your lordships, and if your lordships say that you prefer to do round one from both sides first, then of course we will do that. But if saving that, we had planned to do everything from one side and then everything from the other side, my lords, yes. So if we do follow that course, we, the insureds, will aim to finish by 2:30 or 3 to leave some time for reply tomorrow. There's quite a generous reply allocation tomorrow, which we probably won't need all of. And Melina Friend will stand up after us and use the rest of the afternoon. My Lord, ground one first. The clause, the savings clause, if we just start with it, it's the key bundle tab 8, page 380. And you'll see it on under the word savings, and these words we'll be coming back to again, as my lords know. I should also show you, well, before I do, let me just say this is a composite policy. So this one document provides for an insurance contract for each of the arena insureds with their loss calculated separately, and that has been resolved at a separate hearing for Mr. Sullivan. So we have the Gatwick wording. That's at key bundle tab 9. I just want to show you the other savings clause, mainly to show you that it's very similar, and therefore I probably won't go to it very much. And all that's key tab 9, page 501.
You can just give us a moment, Mr. Kramer. There seems to be a technical...
Yes, technical issue.
Yes, Mr. Kramer.
I don't know if we can find a hard copy bundle of some sort. Does my lord have the key bundle? No. We could at least give you that, if my lord wishes.
Yes, that would be very helpful, thank you. As long as it's not depriving anybody else.
I think it's unmarked. And my sisters will take it out of my fees, so it's no problem. We're at tab 9. We're in the Gatwick policy, and we should be at page 501. And the savings clause there is about 2 paragraphs above the word definitions, and it's less any sum saved. And my lords will see it's very similar to the arena or Bath Racecourse. We sometimes call it arena wording, and that's because they're both very similar to the standard wording. And generally speaking, I'll be focusing on the Bath Racecourse wording just because it's my client's policy, but none of the parties say that the differences are material. We address the principles of construction in our written case, which I don't need to take you to. There's only 2 points, I think, that arise out of those principles, which are broadly uncontroversial, we think. the principles, not these 2 points. The first point is on what we've called the synergy presumption and how much one has to lean into the assumption that there's a full indemnity intended, and I'll deal with that later on in my submissions. And the second is a small point about the extent to which one focuses particularly on the ordinary policyholder and what difference, if any, that makes. I'm going to friend Mr. Gruder is going to touch on that at the end of my submissions on ground 1. So I'm otherwise not going to go to those principles of law, and I will go instead to construing our clause, which is, as my lord saw, at going back, and we'll have to go there a few times or memorise it. It's at Key tab 8, page 380. And for those words, we have charges or expenses of the business payable. Charges or expense of the business payable, cease or reduce, and in consequence of the damage. And ground 1 is not about in consequence of, it's about charges or expenses of the business payable, cease or reduce. Now, just before I address those words, I would like to just put business interruption policies and their calculation into a small amount of context, it being a relatively specialised policy. If we could just look at Hickmott, which is one of the older and traditional texts that explains the history and evolution, he was cited in the FCA test case and various other cases. We just look at the main bundle, tab 109, so it's page 1963 in the PDF. And if we just go within that to PDF page 1967,
you just see what you can do. I'll concentrate.
well, we'll see just at the top, just below, there's a Roman 1 and a Roman 2, and just below that it says it's sometimes said that, and there's a discussion there of the use of a formula in a business interruption policy. And if my lords could just read down.
I'm so sorry, which page are you on?
We're on page 1967.
Thank you.
Of main bundle.
Yeah.
My lords could just skim read down that, it's the end of that page. We say it sets the scene because the savings clause is part of a machinery or formula agreed by the parties, thus comprising their agreed indemnity. And we also say that insurers try and have to try to sideline this formula and the well-known operation of the policies as working to a formula, and instead call it technical pedantry, etc. And we say that's wrong and unworthy, but we'll come back to that general point a bit later as well. Just to go back to the words used, we address the meaning of the savings clause in our written case at paragraphs 29 to 31. And if we could just set the scene with the facts. If we go to the agreed facts, which is in the key bundle, tab 1, page 17, these are the facts of the CJRS scheme itself. And they're set out in paragraph 37. And the short of it was that the CJRS was a grant that reimbursed 80%, and then later on, during the pandemic, 70% or 60%, of a furloughed employee's wages up to a maximum amount. And also reimburse the corresponding employer pension contribution and the employer national insurance contribution, although those two only until the 1st of August 2020. All of that's, I think, set out there. Now, in the clause, which again is at key tab 8, page 380. It's common ground that all three of those charges, that's wages, pension contributions, national insurance, they're all charges or expenses payable by the business. And ground 1 is about whether on payment of the CJRS, the furlough payments to the employer, these charges, wages, national insurance, employer pension, ceased or reduced within the meaning of the clause. And that's ground 1. Now, the parties agree, and they're not telling you anything you don't know, that cease or reduce mean come to an end or lessen. And the disagreement lies in what they mean here. What does it mean for a charge or expense payable to cease or reduce? We say the ordinary meaning of charges or expenses focuses on what the insured is liable to pay, what they're charged, what their expense is. We say that does the amount they have to pay reduce or not? That's the question. What are they being charged? What is their expense? And we say that if someone else is funding or reimbursing that charge or expense, that doesn't alter the fact that the charge is payable by the employer.
If the scheme had been structured differently and for national insurance contributions, instead of being reimbursed, they had simply been waived to the extent of 80%, because it's the government in each case, you say the result would have been different, do you?
If the national insurance had been waived, it's difficult, may depend what waive means, but for example, let me give the example of business rates relief.
Instead of paying national insurance and then getting it back,
yes,
the scheme had said you don't pay national insurance to 80%, you say that would have made all the difference.
That would make the difference, because we know, for example, there's business rates relief where that did happen. There was a relief granted. You do not have to pay the business rates. The charge did reduce. So there's compounded within that hypothetical, there are two particular issues. One of them is the reimbursing party, in this case for national insurance, is the party to whom the sum is payable rather than a third party, whereas the government is a third party to the wage the wage cost, and a third party to the pension cost. But that's not true for national insurance. And then the second point is the mechanism. If that makes a difference, does the fact of reimbursement still take the payment outside the clause, or is it equivalent to a relief, etc.? So there's two particular points, and it obviously would be possible for one conclusion to be reached on national insurance because it's the government that's doing the reimbursing, and another to be reached on the other payments. This is a point that arose in the Court of Appeal from Lord Justice Phillips. So for the other two payments, where the government is just reimbursing a charge that is maintained, is payable, and is paid by the employer, so that view could be reached, but we say not, for the additional reason that they chose, as my lords adverted to, a reimbursement rather than a relief or a waiver. And there could be, one can conjecture that it made a difference. The national insurance pot is a different pot to the disaster relief pot, so that may be why they did it, my lord, I'm conjecturing. But that's where our case sits, my lord.
So for you,
yes,
it is a fundamental importance that it's reimbursement rather than waiver.
It's fundamental importance that it's fundamental that it's reimbursement rather than waiver, but it's also fundamental that it's reimbursement by a third party, which therefore is much further from any sense in which the fee is not payable, because the wages remain payable, are not paid back by the payee, which is the employee. My lord, we say that the word payable supports this. It wasn't given very much weight, we think, and sufficient weight in the courts below. The meaning of payable, dictionaries are only going to take us so far, but the meaning of payable is to be paid, due, owing, falling due. We cite that in our written case at 29. So the focus is on something someone is liable to pay, so on a levying by the payee of the charge. And we'll show you, in fact, the Mobis case on that shortly. If we look at the Treasury direction, we have to go to the main bundle for that. That's at tab 14, page 564. And if we go to page 566, this is not a document for construing the contract, but we say, reflects the ordinary language of the words and the sense of the words that are used in the contract. So if we look at paragraph 2.1, we can see, using English in a normal way, the Treasury direction makes clear that the employment costs are incurred. It said incurring costs of employment. And then 2.2 makes clear that it's just reimbursement of the expenditure. Expenditure means expenses incurred or to be incurred. And just while we're here, if we go to 575 in this document, sorry, it's 575 has a heading at the bottom, expenditure to be reimbursed, and then over the page at 8.1, A, you can see the gross amount of earnings paid or reasonably expected to be paid by the employer to an employee. So as my lords have already appreciated, the mechanics are that the employer incurs and then pays the wages. And then they're reimbursed. Effectively, it's funded by the Treasury.
Does it have to be reimbursement? It talks about to be incurred.
I think the agreed facts record, my lord's right, it is possible to be funded CJRS in advance of a wage cost. That didn't happen for our client, as I think the agreed facts show, but certainly that was possible, and that's why it says to be incurred. Now, we say any reasonable reader applying the savings clause would understand that the wages have not reduced. If you're asked what the wages are, you would say what they are. They're the same. These are the wages I've incurred. These are the wages they haven't reduced. And insurers slide around this a little bit. If we just look at key tab 3, so this is insurers' written case. My lord, page 76. So there, at paragraph 10.1, the insurers say the payments reduce the charges or expenses in the form of wage bills. Now they're correctly, we say, identifying that the question is, what is the wage bill? But the problem for them is that the wage bill did not reduce. And so slightly later we see how they put it at page 78, paragraph 14.3. They talk about the cost and or burden of the wages being reduced. We say that's a very different thing to the wage bill. It's not actually true. The cost of the wage did not reduce. The burden reduced only in the sense that there was an inflow of money, as one often has as a business. But in any case, one can see an evasion of the words actually used in the policy. Now, what does a reduction look like? A reduction obviously includes where, and this happened in a lot of cases, including in this case, where the furloughed staff's wages were reduced to 80%. So the way the scheme worked was the employer was permitted to reduce the wage to 80%, in which case they were fully reimbursed, or they could voluntarily keep the wage for the furloughed employee at 100% and fund the other 20% themselves. And the mechanics change slightly later, but that's the gist of it. And we say, well, obviously, and this is allowed for here, obviously the reduction from 100% to 80% was a reduction in the wage. There's an agreement whereby the employee is still going to be paid 80% even though they're not doing any work, and that's a reduction. And so that 20% is, in contrast to being reimbursed for the 80%, is a reduction. If we look at the guidance, there's another example at main bundle tab 30, page 866. This is some of the government guidance, first published in April. And if we go to page 871, this sets out some of the conditions explaining how the furlough scheme's to work. And it explains that you have to pay the 80%. And if you see the third paragraph, it says employees cannot enter into a transaction with the worker which reduces the wages below the amount claimed. So you can't reduce the wage to 70% and still claim 80%, of course. But we say this is the natural meaning of reduced. The wage bill is the amount that is due to the employee. Now, stepping back from this particular example, if we just look at how savings clauses are generally understood, and I accept this as a novel situation, but if we go to the main bundle at page 2066, which is tab 117, this is Glynn's business interruption sort of handbook. Glynn is also one of the co-authors of Riley. And if we go to page 2071, we'll see basic summary of the business interruption calculation on the left under 1.3. And we'll see a set of bullets that you have a revenue, you then deduct the actual revenue. We'll come back to these mechanics a little bit later. Third, you have a rate of gross profit. That doesn't apply to our policy, which is a revenue policy rather than a profit policy. Fourth, you then add in the increased costs incurred. And then fifth, you deduct any cost that P has not incurred. So the focus is on incurring costs. What costs are incurred? And this is a point I'll come back to later, you have to see the machinery all together, which is summarised here. You've got revenues at the top, and then you've got costs in points 4 and 5. And the same approach was adopted in the Mobis case in the New South Wales Court of Appeal. If we go to main bundle 95, so page 1723 is the decision.
Sorry, 1723.
1723. This is not one of the furlough cases. This is about depreciation. And then at 1734, paragraph 150, the first part of that paragraph, sorry, I may be going too fast. So the first part of paragraph 150 speaks to the formula which the parties have set up. And then the second part, talking about the different integers, speaks to the saving not being a sum incurred. It says the last integer identifies a set of amounts, those charges and expenses, that payable out of gross profit, and directs attention to the sum saved, that is not incurred, if any, in respect of these amounts. This is just, and this is not a dictionary, this is a court, just showing the natural understanding of these savings clauses. They refer to incurral of costs. What costs are incurred and what costs are not incurred? And it's also worth skimming through paragraph 151 over the page, The second sentence goes to a point that the use of the word payable, not paid, for example, focuses on the liability, on the liability relationship between the insured and the payee. Now, Mobis, like the Synergy case, was about whether a reduction in depreciation fell within the clause, which is not a reimbursement, and one can see why they were focusing on these particular words to decide whether an accounting adjustment counted as a reduction in a sum payable, and different views were reached in those two cases. But the general understanding of the clause, we say, remains right and useful, and that is that a savings clause is about incurral of costs, reduction of actual bills, and so coming to the scope of the dispute, which is relatively narrow, we all agree that if the actual costs that you pay on your electricity bill or on your security guards reduce because the factory burns down, well, that's a reduction. And we agree that where there's a relief, as there was with business rates, that is a reduction because the rates were no longer due. The higher sum was never payable. The parties also, they do agree that there's a distinction between a liability for a charge ceasing or reducing and a reimbursement. But if we look at insurers' written case at tab 3 of the key bundle, page 83, my lord, paragraph 27, you'll see insurers recognise a distinction. They call it a conceptual distinction. Now, we say it's a fundamental commercial distinction and a distinction of language, and we'll come back to that. So the dispute is, if there's funding paid to the insured that is directed to funding a particular bill, does that reduce that bill? That's the dispute. And just to see how far that goes, if we look at paragraph 34 of their written case, they say, as they logically must, this applies to any payment to an insured that is specifically focused on, or the word they use is hypothecated to, a specific bill. So even if it's from a donor or a shareholder, if they're saying, I'm going to fund your wage bill, then the wage bill is reduced, they say. Now, we say that's wrong. We say it's contrary to the natural meaning of the words. I've dealt with that. We say, second, it collapses a basic commercial distinction, and we'll come to that. And third, we say it disregards the structure of the policy, which I've prefigured, but we'll come to as well. Just before we do, I'd like to show you the Princess Theatre case. Other than the Stonegate decision and the present case, the main reason judgment on this is Princess Theatre, which is Supreme Court of Victoria. Main bundle, page 1762. And this is a furlough case. We say the reasoning is persuasive. Now, the savings clause is set out at 1771. This is a decision of Justice Osborne, 24. On page 1771, we can see the savings clause 2 paragraphs above the number 18. It's materially the same as ours, because this is internationally standard wording. And then, to just look briefly at the conclusion, if we go to 1793, paragraph 466, it's not a complex point, and it won't have escaped your lordships before this minute, but we rely on it. It's simple. the whole premise of these payments, and it's true of CJRS as well, is that you continue to incur the wage cost. The wage does not reduce. Instead, and this is the last sentence there, there's a new revenue stream. And that's a separate matter. It's a separate matter under the policy. Policies do provide for revenue streams, and we'll come to that. But this is a savings clause about costs. It's the 4th bullet point in the CLIN list. And it's just about...
It says here it could be utilised to pay these expenses, but under this scheme, it had to be, didn't it?
Under our scheme, it had to be. I'm not sure that it didn't there. That might be loose language, but I can't confirm that right now. The conditions are no doubt set out somewhere. Someone will frantically look that up for me now. But my lord is right. But in any case, one wonders why that matters. If you're a business and some money comes in and you hypothecate it to a particular expense, why would that not be enough for insurers? Why wouldn't you then be able to say, well, the expense is reduced because I've got money that offsets it? Of course, that's what businesses do all the time. That doesn't reduce the expense because it collapses the distinction between revenues and costs. So insurers say, well, it matters if the funding stream itself was devoted only to that expense, but we don't see why that should matter on their logic. Once you open up, you broaden the scope of the clause to what they call the economic reality, then it's difficult to see where you stop.
Sorry, can you give me an example that you have in mind there?
So you get a general, well, you might get, you either earn revenue from your races, or maybe you get a generalised grant from the government. These also existed for small businesses. And they come in, and you say, probably in your finance meeting, well, that covers our wage bill for our employees this month. The problem is we've still got to pay for something else. So you allocate the monies. Maybe you physically allocate them and send them out to the employees, or maybe there's a separate account, or maybe you're just doing it notionally as a matter of management accounts. There's always money that's allocated to pay expenses, of course. So we say, the insurers say it's a pedantic lawyer that would say there's a difference, more than a conceptual difference between reimbursing. But we say, well, it's not pedantic, it's basic, and it's not legal either, because it's commercial. So this, I think, is the reason that taxation and accounting practices come into some of the arguments here. We touch on this in our written case, paragraph 50. Now, firstly, at main bundle, tab 31, page 874.
Bundle page 80, did you say?
Bundle page 874.
Oh, okay, I misheard you. Thank you.
This is just about taxation. And you see under the paragraph under general description of the measure, it's explained that these grants, and that includes job retention scheme, CJRS, in the bullets above, they supplant income, supplant revenues, and so they're taxed accordingly. And the accounting standards, we can see, this we summarise in our, probably easiest in our, actually we see it in the statement of facts. That's at key bundle tab 1, page 23 to 4. Paragraph 78 to 81. Now, the core point there is that the receipt, this is just what accountants are doing. They're doing it for their own reasons. They want a true and fair view. No one says this is determinative of what the contract means. But we say it and the taxation and everything else reflects the normal commercial understanding. And the point here is that when you receive a grant or a fund for specific operational liabilities, that doesn't mean the liabilities are treated as gone and you don't account for either. Rather, the liabilities remain and the grant is recorded as other income or grants received. That's under the UK financial reporting standards. As was noted in Stonegate and may be noted here, the IFRS, which is the international reporting standards, allows you to do it both ways. You can net them off and then therefore disclose neither. And I think the same is true of US GAAP. But we say the fact that you must under UK and that you can under the others and the taxation position, they all reflect the basic commercial distinction between a liability and its amount and an income stream and its amount. These are distinct in every business person's head. They all do a profit and loss account which has income at the top and expenses at the bottom. These things are thought of differently. And just because an income is hypothecated to a particular expense doesn't stop it being an income when you read your clause which says, has my cost reduced? There's a timing issue as well. We say that the insurer's construction, so just a step back, the savings clause is pretty simple to operate on our construction. In any month you look at, in the indemnity period, you look at whether there's a reduction in revenue, but you also in that period look at whether there's a reduction in costs, so what was your wage bill? And if there's a reduction in costs, you offset that to an extent against your indemnity claim on the revenue. And you look at your indemnity period, and the costs, naturally, the July wage bill will look to the July revenue, and that's how your indemnity is going to work. But on insurers' basis for this clause, it doesn't work quite like that, as I'll show you. So just to give you some context, after the judgment we had from Ms. Justice O'Sullivan, the first major trigger, as you'd expect, of the policy is around 18th of March, which in this case was closure of racecourses, etc. The indemnity period is 3 months. So the question then arises, 2 questions. What if your CJRS grant comes in outside the indemnity period? And what if your CJRS grant is repaid to the government, but outside the indemnity period? Now, insurers have addressed the second of those. We look at their arguments at Key Tab 3, page 84. This is paragraph 29. So the insurers say here, my lords, we raise the point, which is that the government set up a voluntary repayment scheme. So there's no clawback, but there is a voluntary repayment scheme which allows businesses to repay money that they've had in CJRS. And that was set up as early as June 2020, and the documents are in there, and we might go to them later. Now, you're unlikely to do that immediately because you're still in the throes. But people have paid money back to the government, and the question is what happens there. And the insurers have said in paragraph 29, and one can see tactically why they've said this, well, if you go and pay money back to the government outside the indemnity period, that's too late. But we accept, and this probably didn't happen very much, if you pay the money back to the government within the 3-month indemnity period, then the wage has not reduced. Or more accurately, it reduced and then unreduced because you were reimbursed but then deimbursed, if that were a word. And so the net position is that you still have taken the economic burden. But if you repay after the period, then somewhat arbitrarily it seems, your payment has reduced because you still had your CJRS when the music stopped at the end of the indemnity period. Now, there's 2 points about that. One is that that's arbitrary and creates bizarre distinctions where it just so happens when somebody's repaid their CJRS, which highlights the problem with reading reimbursement, which is necessarily going to be at a different time to the expense, into a time-limited indemnity clause, which makes perfect sense when you're just talking about costs. When was the cost incurred within the 3 months? But if you turn it into a cash analysis and bring reimbursement in, then you end up with arbitrary results based on when the reimbursement was paid back. But we also say it must follow that if, on their analysis, and they normally talk about CJRS payments being what makes a difference, if the CJRS grant is not received during the indemnity period, which necessarily it won't have been for the last month of each indemnity period, there are documents about this. It typically takes 14 days for a claim to be processed and then 6 days to pay, but that's in the guidance, but it doesn't really matter what those numbers are. Nobody can pay instantly. So there will always be some cost that would be up to the end of the indemnity period, and then the reimbursement would happen later. And on insurers' case, it must be that those were not reduced by the reimbursement because it doesn't fall within the indemnity period. Now, we say this is all uncommercial and shows the problem with reading reimbursement into the clause. But we do also say that it's vital to know, if we were to lose, it's vital that people know the answer to those questions so that they know which CJRS does go to reduce. And we'll see what Mr. Scory says about that timing point. So that's the commerciality, which is nothing much more clever than costs and income are different for everybody when you're reading the clause. The third point is that the formula makes that clear deliberately, which I've prefigured earlier. But if we look at the machinery, we say that the insurer's argument ignores the place of the savings clause within that machinery. So, my lord, if we go back to the policy, this is at key tab 8, and if we go to page 325, this is our schedule. So you'll see on the page 325, this is the business interruption schedule. You'll see there's an estimated gross profit basis, but that item's not covered. Then you have estimated gross revenue basis, and that is covered. And you'll see some figures for cover across the group. You've also got rent receivable and increased costs of working. So this is a gross revenue basis. And if we go to page 375, we can see what that means. And the bottom half of page 375 shows that you calculate your reduction in gross revenue initially as against the prior year. And some of the mechanics for that are on page 374. But the crucial point, and we can now also, I think we need to see the definition on 372. Crucial point is, firstly, it's a reduction in revenue, not profit. So you just assess the amount by which your revenue decreased in consequence of the peril. And secondly, the definition of gross revenue at 372, it's money paid or payable for work done and services provided in the course of the business. Now, not every income is included there. Just money paid for services provided. What does that mean? If prior to the damage, the peril, the racecourses used to get donations from customers who support racing, or they got grants from the local council that wanted to uphold the racing business, and if those donations or grants then dropped off as a result of the pandemic, there's no cover for that reduction in revenue because it's not within the definition of gross revenue. It's not a protected income stream. So the indemnity would not increase and the insurers would benefit from the narrow definition of gross revenue, and it's proper that they do, because the parties chose to leave the insured under indemnified as against its total losses, if you want to use that terminology. And the premium was presumably fixed accordingly. Likewise, if there are increases in income as a consequence of the peril, so as a result of the peril, lots of people who don't want their racecourse to close down donate money, or there's general government grants, and there were local business grants, let's say there's a general government grant, or let's say that they received furlough payments, which they did, CJRS grants. Here, the insured benefits from the limit on the definition of revenue, because when you're assessing the net reduction in revenue, you don't take into account these revenues that were actually earned, because they're not within the definition of gross revenue, which only insures against money payable for work done and services provided. So the insured is then over-indemnified because they've received some revenues that don't fall within the definition of revenue. And that is proper too. And our point on the formula is this: the agreed gatekeeper for what income does and does not impact the indemnity is the definition of gross revenue. If that definition were broader, we wouldn't be here on the savings clause. So what the insurers are doing is trying to get in an income, a revenue stream, as the court in Princess case noted, a revenue stream that they can't get in through the proper place in the policy, which is the analysis of reduction in revenue. And they accept they can't. They accept the grants don't fall in there, nor would donations. So they're trying the savings clause. And we say that's not the place the policy contemplates. It contemplates that revenues are dealt with as revenues and costs are dealt with as costs. So how are costs dealt with? Oh, just before we get to that, it isn't outlandish to suggest that the definition of revenue could include these other income streams. We know that the church's policy in the test case included coverage for the revenue stream of donations, and government grants are often included in policies for tech businesses, for example, that do research. But for this business, the cover was the cover. Now, there are a couple of other income streams that are also insured. So I mentioned rent receivable. There's a separate cover for rent receivable, which is on page 376. But that's not relevant here, but I just didn't want you to think that that was an exhaustive definition. There are a couple of wrinkles to it, all of them expressly provided by the policy and priced. Now, turning to the cost side of the ledger, the bottom half of your management accounts, what if a cost increases as a result of the peril? So, flooded factory needs more electricity to heat it up or to dry it out, maybe, or you have to pay higher wages to replace the fact that some of your machinery is not working properly. The answer is that you have no cover for that unless it falls within the increased cost of working clause, which you can see at the bottom of 375. So if you have increased costs that are within that definition, which is broadly mitigatory expenses or expenses that are necessary to avoid the business going further downhill, then you're covered. But there's no general, unlike reduction in revenue, there's no general cover for increases in costs in consequence of the peril. Because that's the policy the parties have written. So if there are lots of costs that are incurred and fall outside that definition, then the policyholder is under-indemnified, if you want to use those words. But the theme that it's clear I'm trying to get across is that saying someone's over or under-indemnified as against some abstract actual position pays no respect to the policy formula that the parties have chosen, agreed and priced. Now, could you try to recover your increased costs through the reduction in gross revenue clause? Could you say, aha, the economic reality is that because of my increased cost, I've had to devote some of my revenue to that. And therefore, I can't really say that I'm going to net off that revenue, and it's not part of my actual revenue in the revenue clause. Now, of course, you could not. But we say it's the same sort of thing as the thing that the insurers are trying to do with the savings clause. The revenue's about revenue, the cost clauses are about costs. Now, the other cost clause we know is the savings clause, which is at 3.7. Well, first there's particular settlement terms at 3.7.8, various of which define exactly what the parties intend. So there's an alternative trading clause at the top of 3.7.8, which helps to understand what sorts of revenues would fall within the definition of gross revenue, being costs that were, revenues payable for work done, etc. And it says, well, if you move premises, that still falls within it in alternative trading. And then you've got your, in passing, the peril we're dealing with is on that page as well, denial of access. And you'll see that's B on that page. And then we have our savings clause on page 380. And the savings clause reduces the indemnity if you have a saving of a particular cost as a result of the peril. And it's not like the reduction in revenue clause, which looks at total revenues across everything. Here you've got to identify specific charges or expenses that have reduced, and if you can, then you put that into your formula alongside the revenue element and the increased cost of working element, and you come out with an indemnity. And we say that shows the illegitimacy of trying to read revenue in there, because the parties, ordinary policyholder or otherwise, will read their policy, they'll see it's a complex formula that's deliberately fixed in order to minimise, or to some extent, the costs of what can be a very expensive loss adjustment exercise, and also to define the risks of the parties, much better than just saying, we will indemnify you for business loss, which causes a big argument. So, this is the way the parties have done it. Any income in revenue goes under the revenue clause, and you would then read the savings clause as just being about the charges or expenses, in the same way the increased cost of working clause is just about the costs. It says additional expenditure. There's no economic reality to read into that. There's no additional netting off. The netting off happens between the revenue clause and the cost clauses. There's no additional netting off permitted within the savings clause to net off a reimbursement, a revenue stream, against a cost. I think the final major topic is the full indemnity principle.
Presumably you would accept that if, in the absence of the furlough scheme, the insured had laid off employees and reduced their wage bill, that would have fed through in savings and hence benefited the insurers, in that they would have had less to pay.
They would have had less to pay because there was less to indemnify, yes. It would have benefited the costs of the insured in a way that is within the indemnity.
There may be an ironical feature of your argument that the very fact of getting the benefit of the furlough payments increases the amount you can recover under the insurance compared with what it would otherwise have been.
Well, there is that, and we'll be going into the overall policy points probably in ground 2A. But we say it's just parties insure what they insure. The indemnity is defined by the parties. Each definition will redound to one or other party's benefit in different circumstances, as I tried to show you with the revenue clause and the cost clause. That is inevitable. As soon as you define something, you exclude things, and that will benefit one or the other, depending on timing and what you're talking about. So it's just, of course, in a different world, the cost would have reduced, and you'd have a different claim because you've agreed a different claim. So, my Lord, we don't shirk from that. It's just the words. And equally, had the revenue clause been broad enough to include grants, then the grants would have come in. And had the grant actually been a payment for services within the definition of revenue, then the grant would have come in. It's just a matter of whether you fall within the words of the clause or do not. So just on the indemnity, the full indemnity principle, ultimately this is unlikely, I think, to resolve this, but there's a general point going off the case law. We can see the meat of this point from, I think, from the insurer's written submission at tab 3, page 79. So we'll see quotation at paragraph 17.11, a quotation from, as was Mr. Justice Flo in the Synergy case, where he accepts that he's stretching the word payable, and he explains why he does that. And he effectively says, I'm going to stretch words if I have to give a construction for as close to a total indemnity as I can, unless it's incapable of any other construction. So this is the definition of a strained construction, and we say it's not legitimate. Now, paragraph 17.4, insurers try to downplay that a little bit. And in particular, in part point 2, they say it wasn't central because Lord Justice Flo, as he then was, said whether or not my decision was right or wrong. But that's not a fair representation of what happened. So I'll show you that now. But first, you'll see Jacobs at 17.41 is summarised, and then we've got Synergy.
Just going back to 17.3,
yes,
where they summarise the way Justice Butcher
yes.
put it. If there's any room for argument,
yes,
contractual provision should be construed. So you
yes.
disagree with that?
I disagree with that. That's straining, yes.
If there's any room for argument, you disagree with that?
I say the test is not that you reach a maximal indemnity construction if there's any room for argument. I say you construe the contract.
So, but indemnity does come in as part of the context?
So, the fact that this is a contract of indemnity is obviously relevant. You need to understand what the parties are doing, why is the insurer paying for some costs, etc. But it goes nowhere to the construction, at least on the points that we have here, as to the particular scope of the formula, because the formula has supplanted any general sense of an indemnity. So, if we go to the main bundle at page 153, paragraph 179, so the first sentence of paragraph 179 is Lord Justice Flo, the Chancellor, Mr. Chancellor Flo, saying whether my actual decision is right or wrong, and there he's talking about depreciation. He says, nevertheless, the principle is right, and he takes that from Mr. Justice Butcher, and this is the principle of taking it, and you see the end of that quotation, you go for an indemnity if it's possible to construe it that way, which is a bit like the words that my Lord just read to me. So all of these are straining principles, and we say that's wrong, and has rightly led to substantial criticism in the foreign courts. I don't have time to go through all of that, but if we just go to our written case at tab 2, page 31.
Well, presumably you accept the general principle that if language is ambiguous, you can have regard to the purpose of the contract in construing it.
Of course.
And the purpose of this contract is to indemnify the insured for their loss, isn't it?
Absolutely.
In a broad sense.
It is.
And if you've got one construction that clearly fulfills that purpose, albeit there may be other ways of fulfilling it, and another construction which clearly defeats that purpose, you would prefer the one that promotes it.
No, that's not right, because it depends on, you have to read the overall policy. Your premise has to be that in everything the parties are trying to make an indemnity of the actual loss. But that premise is immediately defeated by the fact that you have a formula that limits revenue, doesn't give a general cover for costs incurred, only costs that incurred in particular mitigation, has a savings clause. So each of these has its terms and has a function. Now, if there could be situations where at an edge you might say, well, that construction makes no sense because it doesn't reflect what this policy is about. But that, you'd have to be quite far along to get to that, given that
the policy is not just trying to provide an arbitrary sum, it's trying to, there may be different ways of identifying what loss has been suffered, and when there's room for different views, the policy is giving you a particular formula so as to avoid dispute. That doesn't mean you forget about the purpose of the policy and just treat the formula as though it's a mechanism in its own right in the abstract. Well,
up to a point, my lord, you can have a valued policy which just says this is what you get if the property is destroyed. It doesn't matter whether the number's right or not. That's what we've agreed. And no one would say, well, although broadly speaking it's an indemnity policy, it's a valued policy, but I need to read therein some ability to adjust that number, etc. No, parties have obviously agreed what they've agreed. And here we have a formula which every word of it is limiting the indemnity by specifying. Otherwise, the words would not need to be there. They're all doing something. They're saying, this is how we do it. This is the mechanism. You have to use this bit for revenue, use this bit for costs. This is the extent to which we'll cover costs. We're going to exclude some actual losses, and we're going to include some, we're going to over-indemnify and under-indemnify. We know we are going to do that. But that's the nature of what we're doing in every clause. And once you've accepted that, there's not much room for reading in, oh, but remember it's an indemnity policy, because you've got the words which are reduce a charge or expense, and you've got other words about revenue, and everybody thinks of charges or expenses as what they are. So you would have to really strain, or I think it was stretch that Miss Justice Flo used the word, and we say that's not legitimate, taking some sort of overarching principle. It's equivalent to the construction of exclusion clauses where there's no remaining purpose for an obligation clause if you read an exclusion clause that way, which is one of the only strainings still permitted. If you read the exclusion clause in a particular way, it totally denudes the main obligation of content, and you say, okay, fine, I'm willing to strain. But we're nowhere near that. You can't say that this leaves the policy without coverage. It's got the coverage that's defined in it very carefully through a broking process and with a premium. So just to...
So as I understand it, your argument essentially is it may well be correct that if there was a lack of clarity or ambiguity, however one wishes to express it, you might then fall back to a general idea of indemnifying a loss. But you say here we never get to that because the clauses are unambiguous.
We certainly say that. Yeah, we say they're unambiguous. So if you're looking at work, money payable for work and services, you might say, well, what does services mean? And maybe you would go back and say, well, is it to do with the services that were part of the underwrite that were disclosed as the business's services? Maybe it has to be that, because that must be what the parties mean, because they're trying to give a quantified indemnity. You know, there may be clever ways of paying where you can say, does that count as paying? A more difficult case is probably depreciation, where something's reduced, and you have to say, well, is that payable or not? And different courts have reached different views.
But I suppose what I'm really driving at is the difference between the parties.
Yes.
May just be as to how clear these clauses are. And insofar as they aren't clear, I think you would be accepting that one can fall back to a general idea of resolving ambiguity by reference to an underlying indemnity principle. I think you just say, you just don't get there here.
Yes, that's right, up to a point. Well, so we do say you don't get there, but we also don't say that there's a trump card. That's not the way ambiguous construction is resolved. You still have to resolve it iteratively. You have to consider how ambiguous are the words. Is the focus of the words really in one area rather than another area? What is the overall commercial purpose of this clause, not just of the overall policy? Is the overall purpose of the policy satisfied when I look at all the clauses? This isn't the only clause, the savings clause. So we've got to read it with all the other clauses. And then we say, well, there's nothing left because the purpose of the policy is being satisfied on either construction. Neither of them leads to an uncommercial outcome. And therefore, we say in the more sophisticated iterative approach which you're applying, you don't in fact just say, well, I found an ambiguity, so that's the end. Because ambiguity has no hard edge, as my Lord knows. You can always stretch something. We say these words aren't in fact ambiguous. And to say that it actually includes the economic burden, economic reality, rather than the meaning of the natural meaning, we say is not identifying an ambiguity, it's effectively implying a term. But this is to an extent semantic because we all know there's a sophisticated process of construction which seeks to identify the best meaning, rather than, is it ambiguous, go to step B. So, my Lord, I think that's what we say, and I'm not resisting the fact that it's... One could equally say another way, if there's ever an ambiguity, do you take into account the fact that it's a standard form insurance contract with a complex formula, and then just go with the natural meaning? I mean, that's what you often do. In Hexagon, that's what we do with standard terms. That's what you do where you have a commercial contract. Normally, you resolve it in favour of the natural meaning, because that's what sophisticated parties are intended to understand. So I do resist, I think, where my Lord was premising that question. I think my Lord sees why. Just to finish off the point on the criticism, although I understand that my Lords have gone further in their own minds to an extent on quite how this works. If we just see our paragraph 18, which is at page 31. So at the bottom we quote from that Mavis case which I showed you on the meaning, on the reflection of the word incurred. But there's a general discussion, and there are a number of cases, including English cases and the textbooks, that remind us that there's a formula here. And there, Justice Marr explains why the reader's attention is fixed on the language and the particular formula. And our paragraph 19 refers, in the middle we quote from Princess Theatre, and we also cite the Irish case of Hypertrust, which is we've explained in the footnotes that that's an odd case because the parties agreed by a settlement that furlough was deductible, and so the only point they actually argued about was not whether it was deductible, but whether there was a general synergy presumption, because obviously there were broader issues at stake on that, and in fact the conclusion the court reached was that there wasn't. And the core of it is in that paragraph 19 quotation. You'll see, yes, it's an indemnity policy, but it's not an at-large indemnity policy. And once it's not an at-large indemnity policy, actual loss, then all that tells you is the premise is the parties want to indemnify for the things they've agreed to indemnify under the formula. So if there was a part of the formula where a construction made no sense as an indemnity, it's hard to come up with an example, then, of course, you need to think, well, that makes no sense in this policy. But no one's suggesting that's true here. So, my Lords, that's where I was going to sit down and let Mr. Grieder just make a more general point on the construction approach, unless there's any more questions on ground one.
Yes, thank you, Mr. Kramer.
Lords, I would like to deal with one very specific point, which is the reliance of the insurers on paragraph 77 of the FCA test case and the alleged dichotomy between an ordinary policyholder construing a insurance contract in the eyes of the ordinary policy rather than a pedantic lawyer. And that's the way the insurers say that the policy, which they drafted as a standard term, should be construed. Now, since the FCA test case, and we'll come to this a little bit later, that type of argument has been put forward by policyholders to try and ameliorate the strict wording of policies. Strangely enough, in this case, it's the insurer itself who's trying to use that wording to move away from, we say, the correct strict construction of this policy. And one sees the reliance of that in paragraph 16 of the insurer's case. You probably don't need to turn that up, and I would perceive that my lords are familiar with paragraph 77 of the FCA test case, but I'll come to that later when I explain why the majority of the Supreme Court expressed themselves in that way in paragraph 77. But this alleged dichotomy is the launchpad for the insurer's central argument on construction, that when dealing with the construction of the savings clause, and in particular the words cease and reduce, you should look at the substance rather than the actual meaning of the words used. And one sees this in, for example, it's really peppered in their submissions, but to take an example, paragraph 23.1 of the insurer's case, which is Key Docs Bundle, tab 3, page 82. And they say in that paragraph, the ordinary policyholder would look at these terms in a pragmatic and commonsensical way. They would look at whether in substance and as a matter of economic reality, a particular charge or an expense had been lowered, diminished, or lessened. Now, that is not construing the language of the policy. It's looking as whether in substance you have achieved the same object, which is not, in our submission, construing the language. And another example, paragraph 23.3, Key Documents Bundle, tab 3, page 82. The pedantic lawyer might draw a distinction between, 1, a discharging B's debt to C, and 2, A giving B the amount of his debt to C on condition that B must discharge it himself. But the ordinary policyholder would say B's debts have been reduced in both scenarios. Well, we say someone construing a contract properly in accordance with that wording would draw that distinction. And we don't need to have an insult to call a person who's properly construing a contract a pedantic lawyer. And a pedantic lawyer is being used as a term of opprobrium, but in reality, insurers are seeking to use the ordinary policyholder approach as a license to justify ignoring the ordinary meaning of the contractual language. And we say this is a misuse of what the Supreme Court majority said in paragraph 77 of the FCA case. And we say there is no special rule applicable to construction of insurance contracts. The normal rules of the construction of commercial contracts apply. And when considering paragraph 77 of the FCA test case and the reference to the ordinary policyholder, it is important to recall that it's in paragraph 47, not paragraph 77, in which this court set out the relevant principles of construction of insurance contracts. Not only insurance contracts, business interruption insurance contracts, since those contracts were before the court in the test case. And these principles are no different from any other commercial contracts. And if I can ask you briefly to turn to paragraph 47, which is main hearing bundle tab 54, page 1167, that sets out the principle. And it says that there is no doubt or dispute about the principles of English law that apply interpreting the policy. They were most recently authoritatively discussed by this court in Wood and Capita and are set out in the judgment of the court below in those paragraphs. The core principle is that an insurance policy, like any other contract, must be interpreted objectively by asking what a reasonable person, with all the background knowledge which would have reasonably been available to the parties when they entered into the contract, would have understood the language of the contract to mean, would have understood the language of the contract to mean. And this court applied the normal principles of construction which have been emphasised by this court and by the House of Lords before it again and again. And Wood and Capita, which it's not necessary for us to turn up, I'm sure my lords are very familiar with it, said that some agreements may be successfully interpreted principally by textual analysis because they've been negotiated and prepared with the assistance of skilled professionals. Now, this contract, as you have seen, is of this particular clause about calculation of revenue and the savings clause is a standard contract. You've seen it not only in the contracts before the court, you've seen the same wording in Australia. And this is exactly what we are dealing with here, standard form contracts drafted by skilled professionals on the insurer's side. And construing professionally drafted contracts in accordance with the wording is something which was stressed again and again in cases in this court on construction of contracts. For example, and again, it's not necessary for us to turn it up, paragraphs 17 and 18 in Arnold and Britton. So one looks at the wording used in a professionally drafted standard form insurance contract, and you say, what does this wording mean? And we say it's clear. So if I can come back now to paragraph 77 of the FCA test case, why did, in paragraph 77 of the test case, did the majority of the Supreme Court refer to construing the contract through the eyes of the ordinary policyholder? And it might well be necessary, I think it is necessary, to look at that paragraph, or the preceding paragraphs, and first go to paragraph 75 of the FCA test case, which is the main bundle, pages 1174 and 1175. And what one finds there is that, and it's really, I'm probably going to summarise what was going on here, but RSA was seeking to rely upon a general exclusion on page 93 of 93 pages, which spoke generally about excluding losses from disease, and they sought to argue that effectively excluded cover, which was provided 55 pages earlier on page 38 for losses caused by infectious disease within a particular radius. And paragraph 77, one sees the argument recorded by the majority in paragraph 76. Paragraph 77 is all about repugnancy. It's repugnancy between an obscure general exclusion right on the last page of the contract and the attempt to use that to emasculate, effectively, cover, which was granted 55 pages earlier. And that's why, in paragraph 77, the Supreme Court said the person to whom the document should be taken to be addressed is not a pedantic lawyer who will subject the entire policy to a minute textual analysis, i.e., somehow trying to synthesize an exclusion on the last page to cover 55 pages earlier. It is an ordinary policyholder who, on entering into the contract, is taken to have read through the policy conscientiously in order to understand what cover they were getting. And this then led to a conclusion in paragraph 78, which I would ask my lords to read. And we would say that this paragraph 77 does not set up a different test from paragraph 47. It's merely an application of it. And the contrast between the pedantic lawyer and the ordinary policyholder was made by reference to the point that it's neither reasonable or realistic to expect the policyholder to share the appetite of a pedantic lawyer to engage in the exercise of attempting to apply an exclusion which is buried away in the middle of a general exclusion 55 pages from the section dealing with cover for business interruption loss. But we say that the principles set out in paragraph 47 of the FCA case, and the cases referred in that paragraph, and the cases which have, in a sense, built on Wood and Capita, are absolutely the way you construe this policy. And I did mention earlier, since the court's judgment in the FCA case, the reference to the ordinary policyholder in paragraph 70 has been used by parties, as I've said, almost exclusively policyholders until this case, to try and circumvent or somehow mitigate the normal principles of construction which were set out in paragraph 47. And this has rightly led to a pushback by the courts below. For example, if one looks at the Brian Layton case, which is tab 45A of the main documents bundle, page 1012G, one sees paragraph 40 of the judgment of Lord Justice Popperworth.
So what's the page again?
Page 1012G. I think
That's the Victorian. Yes, there's a case from 1758.
Oh, I'm sorry. Perhaps I've gotten.
I'm still looking at the internal numbering or something, right? I don't know.
Well, I think it might be. Which one are you talking
It's
about?
paragraph 40, and the page I think is 1012G.
What's the name of the case?
We don't have. Oh, G.
We don't have the case. Brian Layton.
Oh, sorry. Yes.
It's the very next case in the bundle.
Oh, yes.
But we're not quite.
We're not
aware
used to
of it.
letters, I think.
Yes.
Yes.
So you want to go.
The letters, yes. So what Lord Justice Popperworth says, and he's clearly got in mind the argument that's been put to him about the reasonable, the ordinary, construe it through the eyes of the ordinary policyholder, is assured such as BOG have brokers who can advise them, and brokers are to be taken to be familiar with the basic insurance principles of proximate causation, a language which reflects on it, or by contrast modifies it. Both assured and broker have access to legal advice, which would involve no pedantry in advising on the presumptions involved in the use of such language. This is part of the background knowledge which would reasonably have been available to the parties. I do not take what was said in paragraph 77 of FCA and Arch as suggesting that the reasonable person in an SME's shoes should not be taken to be familiar with the basic principles of insurance law and the meaning which has been put on phrases used in insurance contracts by consistent judicial authority. Many policies of insurance in many fields contain terms of art which have acquired their meaning by consistent use and judicial interpretation, which it's the duty of brokers to understand and, if necessary, advise on. And one sees Law Justice Mayall's at paragraph 65 says, this policy be interpreted objectively as it would reasonably be understood by an ordinary policyholder, in this case the owner of a petrol garage, albeit with the benefit of advice from a broker familiar with basic principles of insurance. So what one has, and this is merely one example, an earlier case called Corbyn and King also introduced the ordinary policyholder would have a broker. And what this is the courts below dealing with arguments which have been built upon paragraph 77 of the FCA Supreme Court decision. And the argument is that that somehow introduces a less rigorous a principle of construction than the ordinary principles of construction in Wood and Capita, Arnold and Britton and so on. And the way they have tried to push back on that is to say, well, the ordinary policyholder can be expected to have a lawyer to advise him, can be expected to have a broker to advise him, when in reality, the real answer is that paragraph 77 is not in any way seeking to modify the normal principles of construction which apply to these insurance contracts as set out in paragraph 47 of the FCA test case. And we say that if the wording of a professionally drafted agreement, which this is clear, which we say it is, that wording should be applied according to its terms. And those are my submissions.
I suppose we've always had some issues about just how objective the test actually is in terms of interpreting a contract, what exactly one assumes that the ordinary reasonable policyholder, you might say here, is expected to know. I think it's taken as read that you are expected to know the relevant law.
Yes.
And in that sense, maybe this boils down to not really much of an argument, because if one's got to accept that normal law is part of what is assumed
Yes.
by the reasonable or ordinary policyholder, then I'm not sure there's much in it. It's the pedantic lawyer that is the issue, I think, perhaps, as opposed to... I
mean, the pedantic lawyer is used clearly as an insult, really, or at least a type of criticism. But some, if one is looking at the meaning of words, one has to look at the meaning of words. You can't say, well, the interpretation I'm going to give it is not really what the words mean, but it's more consistent with...
But I suppose what I'm putting to you is, I think you would accept that it's perfectly acceptable to describe the test as, well, one is looking at the meaning of the words to the ordinary policyholder, albeit that that ordinary policyholder is regarded as having the sorts of legal advice so that the normal understanding of the law would be taken to be understood by the ordinary policyholder.
What I am pushing back against is the use of, which these insurers do, the term ordinary policyholder in paragraph 77 of the FCA case, to somehow allow some flexibility or a sort of wishy-washy aspect of construction in order to say, well, the words don't actually mean what we want them to mean, but in substance you achieve the same object by our argument. And we say that's not legitimate, because if the words are clear, which we say they are, you construe the words, especially in this case where it is a formula.
Thank you.
I mean, if you remember Thornton and Shoe Lane parking,
Yes.
and Lord Denning's remark about how you needed a giant red hand to point to the exclusion clause.
Yes.
In a way, the point being made in paragraph 77 of FCA, I think, was rather similar, that it
Yes.
may be a pedantic lawyer would comb through all 93 pages
Correct.
and would notice there was an exclusion clause that seemed to rule out the cover given in bold 50 pages earlier. But the ordinary,
Yes,
it's a similar. I think it's a similar point to the one. Lord
I think
Denning
you're
made.
right, and I think one could look at paragraph 77, or the argument it was dealing with, something like a sort of, if one sometimes goes to the market and sees someone playing a three-card trick, and somehow the insurers were somehow trying to play a three-card trick on the policy. I quite agree with you, my lord.
Yes, Mr. Kramer.
Unless there's any more on ground 1, I'm going to address ground 2A. And as part of that, of course, I'm going to explain to you how ground 2A and ground 2B fit together. But just before I do, can I just set them up? So the clause again is at, although you'll remember it, it's at 8, P bundle 8, tab 8, page 380. And the words we're now dealing with are the words in consequence of. And the words in consequence of appear in the savings clause, but also the revenue clause that I showed you, and various clauses. It's dozens of times in this policy. They're the wording that link the peril to the reduction, whether it's reduction in revenue or reduction in a cost. Now, it's now, I think, common ground that this is a deliberate importation of a legal causation test. So what including these words mean, or we'll come back to what that test is, but what including these words mean is the parties are deliberately agreeing, because they don't have to include these words, and in fact in the Polikoff case the words weren't there, which led to causation arguments being disregarded. They're deliberately agreeing that even though there may be a causal link between the peril and the reduction in revenue, or between the peril and the reduction in charges, that will be disregarded unless it's proximately caused. That's what they're saying by these words. So we have to first sketch out what proximate causation means. It's a vexed area. I'm going to start with the categories of one Professor Burrows. If we go to the...
This is bringing on board rafts and rafts of what Lord Justice Popplewell was anxious to preserve in the paragraph in the Brian Lakin case that we've just been looking at, isn't it?
Yes.
You look at a word, it looks like a perfectly ordinary word with a perfectly ordinary meaning, but actually it's a heading for whole books, including Hart and Honoré and goodness knows who else, of law about causation.
Absolutely, yes.
Right.
There's no other way of dealing with those words. And proximate causation is, in fact, a familiar concept within insurance as well as anything else. This isn't the only time it comes in, as we know. So if we go to main bundle, page 1917, this is chapter 8 of Professor Burrows's, as he was when he wrote it, his textbook Remedies, and you see there's an introduction section, and the chapter's on compensating advantages. So this is just about benefits received by the claimant. And just in that section 1, there's a reaffirmation, uncontroversially, of the need for factual causation. And then at the top of page 1918, there's a statement that compensating advantages are normally deducted unless they fall within one of these two general exceptions. I just want to address a preliminary point there. So they're often called exceptions in the law. The general rule said to be non-deduction. We cavil at that a little bit. You'll see, don't know if we can keep an electronic finger there, but also look at the hard copy key bundle at my learned friend's submission. So this is tab 3, page 97. Paragraph 66.
Sorry, 66.
Paragraph 66, page 97 of the insurer's submissions. They say it's an exception and should therefore be interpreted narrowly. We say that's wrong. It's an exception only in a particular sense. It's certainly not an exclusion, for example. So the law is, if we just go to tort law for now, the law is that a defendant's responsible for the losses that are legally caused after crediting the benefits that are legally caused. And something not being legally caused is not an exception. It just falls outside the norms of responsibility. A true exception would be if you were crediting a benefit that was not legally caused or ignoring a benefit that was legally caused. So the rule is you're responsible only for the things that are legally caused, and it's no help, and there's certainly no presumption or burden to say that you do or don't fall within the rule of causation. If you do have to go to burden of proof, we do rely on, I don't think we've got time to go there now, but Lord Justice David Richards in the Asset Co case, and this is at page 975 of the main bundle, affirms that the burden of proof falls on the one asserting that the benefit was legally caused and so reduces loss. But I don't think this case is going to come down to that. But in saying that, I want to clear aside suggestions that it's and with respect, Professor Burrows takes this view a little bit, that it's over-indemnification to ignore a benefit, even where it's not legally caused, because the benefit was received. And obviously, as a matter of factual causation, it is over-indemnification, but we say that's not a relevant consideration because the rules are what the rules are. So there's an example that Professor Burrows rightly gives of somebody who's sacked from employment, I think, and goes and enters the lottery and wins the lottery. And of course, the lottery is entirely collateral. So if they can claim against their employer because they weren't able to find another job, they get to disregard the lottery money. That doesn't mean they're over-indemnified in any real sense, because the lottery is simply not part of the responsibility inquiry. And similarly, if the employee was not quite as lucky and went out and bought 1 million lottery tickets and won none of them, you wouldn't be able to claim the cost of that, because although he'd then be under-indemnified, it's just not within the responsibility of the defendant. So we say, and the new flamenco is also a bit like that, we say, although I know Professor Burrows doesn't like that decision either, we say that over-indemnification doesn't help. Legal causation is the rule for responsibility, and we therefore have to evaluate what that means, and talking about something as an exception doesn't really help us. So if we go back to Professor Burrows' book, because the headings used there and the categories are, we say, useful, and also broadly reflect those of Hart and Honoré. If we look at page 1918, you'll see the first category there is indirect compensating advantages. And for this category, it said that the link between the wrong and the benefit is not sufficiently direct. And you'll see the first paragraph, which also another euphemism is that the benefit's essentially coincidental. So it may be factually caused, but it's not within the responsibility, nor does it reduce the responsibility. And this chimes with the common description in the case laws of something occasioning a loss but not causing a loss. See also there, Professor Burrows refers to policy as being behind these rules. Now, generally speaking, I tend to prefer the principal idea, which is Hart and Honoré's. It probably doesn't matter, because what we have to establish is what the test is. It may be that the court has to reach a view. I'm not sure I do. But we say either way we get to the test as I will be formulating it. But I do just flag there that the Hart and Honoré view is derived from what they say are common sense principles of responsibility, and they talk about abnormality being the way we see causation in everyday life, and voluntariness similarly, and this came up in the BDW case, as my lords know. So if we just look at the third paragraph there, because this is the category we're not principally dealing with today, of directness, you'll see the first sentence there.
So which page are you now?
So we're still on 1918.
Okay.
The third paragraph below the heading. So it starts turning to the cases.
Right.
And the point is made, with respect, rightly, that where you're talking about compensating advantages from third parties in response to something having happened, then the causational issue is unlikely to be directness, and we'll come to benevolence, etc. in a moment. And most of the things under this directness category are in fact about the claimant's actions. Were they acting reasonably in a mitigation sense, or were they acting voluntarily or speculatively or independently? Now, just before finishing that point, so...
You've plunged, if I may say so with respect,
yes,
straight into a whopping great pool, which is all about the common law for the quantification
yes.
of damages, without at this stage putting forward a coherent basis for saying that's the sort of causation which is incorporated by the words "in consequence of" in an insurance policy. And for my part, I would need, I think, some persuasion that
yes,
that what you get out of that particular... I mean, there are all sorts of different great big pools about causation in the law. Causation in trust accounts have been completely different from causation in common law damages, for example. And I just think I would like some help as to why it's this pool that you jump into, or that the parties to the contract, when using the words "in consequence of," must be assumed to have been swimming in.
Yes. Well, we know the insurers agree that there's a concept of both factual and legal causation entailed by these words. They say so in their written case at 58.1. We know that the principles in the FCA test case, where the words "as a result of," etc., were used, naturally imported the common law question of what is approximate cause, including successive causes and then concurrent causes. And it's the obvious pool. There's no obvious other pool to go to. Now, there's a reason why some of this discussion feels strange in insurance context, which I'll show you in a moment. But just before I'm just going to sideline my Lord's question very briefly. If we just look at the third-party aspect, so while we're in the directness cases, we have to remember that the benefits are even then conferred by a third party. So in the new flamenco, the money that was disregarded was the money paid by the buyer of the vessel. It was a benefit conferred by a third party, but in no sense was it collateral because of anything to do with the third party. The third party was giving money full value. They were buying the vessel. And so, although we have to remember that the third parties confer benefits all the time, that benefit was not disregarded because the third parties paid for a ship. It was disregarded because the claimant's actions were found to be speculative. So there's always a third party, and although in the cases we're going to look at, it's often about charity, etc., remember that third parties confer benefits all the time in commerce, and they are rightly not disregarded because they are legally caused, because they're normal or not voluntary in a relevant sense, etc. So just to see the separate heading 3 now, and I'm going to return at least from one angle to my Lord's question. You'll see that at page 1922. This is the other heading, which focuses almost entirely on the third parties, the nature of the gift, the source, was it a gift, etc. And here it's harder to formulate a principle, I think it's fair to say. And there's a number of headings of points that apply, and you'll see at 153.1 is the question of directness, and Professor Burrows there in the second half under the sentence, so this is Roman 1, under the sentence, but the essential objection, says, well, as he'd said before, directness doesn't help us that much when we come to questions of third-party payments. And then if we go over the page to 4, we see the familiar category of insurance, etc. So where the claimant has embarked on particular conduct. In some ways, this falls more naturally within directness, except that we can see it's unusual because here this is about the claimant doing something before the wrongdoing rather than in response to it. It's the collaterality of the claimant having insurance, etc. But then when we come to 5, there's a reference to the purpose of the advantage, and Professor Burrows has question marks over whether that's actually helpful as an indicia of what is or is not collateral. And then at number 6, there's a reference to gratuitous payments and the policy objective of not discouraging benevolence. And this wording reflects wording used in various other cases. Without going there, Lord Sumption in Tutor and Villiers talked about purely benevolent benefits. Lord Bridge in Hussein and Taplow talked about benevolence as well. Lord Reid in Parry and Cleaver preferred also a policy basis. Now, this is my coming at my Lord Briggs's question from the side. Normally, we would not be in this category, or most of this category, for an insurance contract. And on our construction, we would not be. Why? Well, under the revenue clause, the question is whether revenue, which is confined to payment for services and work, whether the reduction in that revenue was legally caused. And that is not going to be about benevolence and the like, because it's just talking about the commercial payments for the services. It will be about things that the claimant has done. Similarly, on our construction of the savings clause, the clause is about the charges and expenses, which necessarily are also commercial payments for things, whether those have reduced or ceased. And on our construction, this is the ground 1 point, you're not going to get into benevolence either. The parties are deliberately confining themselves to changes in commercial relationships. And whilst claimant behaviour might affect them, the revenue might be changed by the claimant doing a particular business, but was that speculative? Or the costs may reduce because of the claimant's particular activities. So in the Polikov case, there was an example of the claimant applying their money in a particular way that reduced an interest cost, when actually they could have done it a different way. But you won't get into benevolence because you're talking only about commercial costs. So the only reason, and I'm sensing that my Lord Briggs will be less resistant, or naturally resistant, to talk about directness in the context of insurance, because it's what we're used to talking about. Did that ship exploded and then this thing happened, etc. So the problem is the benevolence. Is this whole part of common law to be imported? And we say, well, no, it isn't, because ground 1. We don't get into reimbursement. But once you bring in the concept, if you're saying, as only the insurers are, well, the parties are contemplating that the indemnity is affected by payments from third parties who may be non-commercial, well, then you get into this other category from Professor Burrows' book, because then you get into the possibility of a benevolent payment or a payment for some commercial motive that isn't just selling something. So we say, if we're wrong about ground 1, then the parties have deliberately contemplated that reimbursements or funding from third parties, this is the insurer's case, not ours, is imported into the savings clause. And we say, if that's the case, then the parties must have intended their in consequence of wording to apply to the funding or reimbursement. And if so, there's only really one place to go. There's only one pool where there are fish that already deal with that particular point, and that's the common law. And so that's why you import benevolence. That's also why it feels strange, because unless you go down that construction route, you will never have to go there, and it's very rare in a commercial contract you ever would have to go there. There are examples, which I will show you, in the insurance context, where equally the concept of benevolence is employed by the court. So that's not the only way of making that point. I think it naturally comes in anyway once you talk about a third-party payment. But it's certainly going to be rare in a commercial insurance contract for those reasons, and obviously much more common in a perhaps personal injury accident contract.
But why are you going to benevolence as opposed to let's look at where state payments are otherwise made?
So,
as the more obvious analogy.
Well, we will be going there, my lord. But the premise of my lord's question is that state payments have a different rule, and we reject that premise. There are differences in the nature of how a state payment has come about, but unless there's a different rule for state payments, and I know the learned professor has a separate section within this chapter on state payments, but it has to be established that state payments are different for some reason, and we say there's no reason or principle for that, although we will come back to that. If I could just, and this also...
Yeah, I'm only just saying,
yeah,
if you're looking at...
My lord's right.
If you're looking at the common law, it's quite clear that state benefits are treated different than benevolent payments by non-state.
My lord's wrong, as I will show him.
Okay, fine.
If we go to the main bundle at 1344, just as I should show you at least one summary of the overall principles. This is the Swinson case in this court. And if we go to 1353, we will see the paragraph 11, starts at 1352, summary of Lord Sumption of the law. And there he outlines what he calls an exception of res inter ales acta for collateral payments. And my lords can, if just read A to B, a gift is independent. And then the last two, we don't need to read probably the middle. The last two sentences of that paragraph, my lord says that policy is behind it, but that doesn't mean one has sort of free case-by-case policy license. The relevance of policy in this area is vexed. It's hard to ignore policy, especially with state payments, where states obviously have policy in mind themselves. But nevertheless, we say it can all be fitted within the framework of principle, which we'll come to. Just briefly on this case and the facts, the court will recall that it was a very unusual case where there was a Mr. Hunt who owned the lender and part-owned the borrower. The lender was Swinson and the borrower was EMSL, and he loaned money to the borrower, EMSL, to repay the loans, and it did so. And the question was whether Swinson, the lender's claim against some professionals, Loic Rose, was reduced because the loans which they were complaining about had actually been discharged by payment. With respect, unsurprisingly, the loss was reduced by the repayment because from the point of view of Swinson, the unpaid loans were no longer unpaid loans, and the repayment of the loans couldn't be collateral because they'd been repaid wherever the money came from. But if we look at 1353, paragraph 13, we do see the generalised point on a hypothetical. If Mr. Hunt had lent the money to Swinson, the lender, to strengthen its position because it had defaulted the borrower, then that would be collateral. And we also see that at 1357, where Lord Mance at paragraph 48 explains why it would be because it would be gratuitous and benevolent. Sorry, gratuitous or benevolent. Even though obviously it's paid by an owner, this isn't a charity or a disaster fund. Nevertheless, it's gratuitous because it's a gift in this example. And gifts are almost always going to be benevolent, and they're definitely gratuitous. And then finally, on this case at 1360, we can see the Neuberger at paragraph 98. So the second half of that paragraph that begins ignoring. He uses the word benevolence, although note, and this isn't the only place I'll be going to in relation to my Lord Burroughs' point, he summarises, we say rightly, that it's whether it comes from his employer, an insurance company, or the government, where there is also benevolence, whether from the government, a charity, or family, or friends. So he at least sees the general rule as applying to everybody, not saying there can't be specific factors for specific state payments, and we'll come back to social security, which is, we think, potentially the tail that wags the dog of thinking about state payments, because it's obviously so significant socially and numerically in terms of the payments. Now, just before we go to that, so I would like to show you, and this is, you can see this in my learned friend's case at tab 3, paragraph 39, so page 87, sorry, page 88. Oh, there's two paragraphs 39, that's why I was thwarted. So the argument here, and this relies on the Chancellor's comment in the Court of Appeal, which is quoted at 39, is that if the insurers win on ground 2B, then ground 2A doesn't arise. And this may be why this point, which we call ground 2A, only took up 2 or 3 paragraphs of the Court of Appeal judgment. We say that that's, I'm afraid, obviously wrong. Ground, and one reason I went to those 2 sections of Lord Burroughs' book is partly to identify that. Ground 2A relates to gratuity and benevolence, which insurers do seem to agree is relevant. They talk about it at paragraph 63.2. And it would arise for any peril where there's a payment like this, so including a disease peril. And the reason I say that, of course, is that ground 2B is not about gratuity and benevolence at all, and it only arises for composite perils. And probably the best, my learned friend Mr. Gruder is going to deal with that a bit later, but the best place to just see that is if we look at Riley at main bundle 2056. And we see towards the bottom, there's a paragraph that begins rates, which essentially summarizes this point. Riley, with respect, is a broadly insurer-friendly textbook. And if we see rate deductions are in, but that doesn't matter for these purposes because it's a fair summary of the point, which is that rates deductions, so if there's a business rates relief, are entirely appropriate for disease covers, essentially because the disease obviously caused the rate reduction. But with regard to denial of access cover, the appropriateness of the deduction of the rates rebate, which was provided irrespective of whether the business was open or closed, depends on the strength of the causal connection between the reason for the saving and the insured peril. Now this is the 2B point, which is if your cover is only triggered on a composite basis that therefore includes restrictions on the premises, but everybody in the country got the furlough payments whether they had restriction on their premises or not, can you say the peril caused the benefit? Now that's point 2B. I'm not going to deal with that now. But it's clearly distinct, and it's a form of directness argument. It's clearly distinct from the 2A point, which is, what if the payer did so benevolently? And just as a payment would be collateral if it fell within the directness chapter, but not the third-party chapter, equally, a payment will be collateral if it's benevolent, even if it's also direct. And indeed, as we saw, Professor Burrows says that most payments from third parties will be direct, and that doesn't stop them being collateral. So we say that's what 2B is going to be and what 2A is and how they're distinct. Now, coming back to 2A, if I could set out my case on this particular pool, the core of our analysis is I think 5 points. Firstly, this is a question of legal causation, and that depends upon an analysis or an assessment of the character and the purpose of the payment. The character includes gratuity. The second point, we say gratuitous payments, which is payments that are not for value, like a purchase, but also not obligatory, like an insurance payout. They have their own factors. But gratuitous payments are those payments that are therefore in either of those categories. They're not for a value, not obligatory. And we say, point 3, it follows almost inexorably, almost, not entirely, from the gratuity of the payment, from that character of the payment, that such payments are out of choice in a causatively relevant way, which we often call voluntary. An obligatory payment's not voluntary, and one that's made for value is voluntary only in the sense that you choose to buy from this person, not another, but not in a legally causative way. So they're made out of choice in a causatively relevant way. They're also often spontaneous and abnormal, if one's thinking about causation in abnormality terms. And they have the purpose, almost inexorably, of benefiting the claimant, because they're made gratuitously to the claimant.
There may be an issue as to whether the CJRS is properly characterised as being not obligatory. Once the decision's made, there's an entitlement.
My Lord's right, and I will come on to address that.
Well, that's pretty fundamental, isn't it? Yeah, because it was obligatory. There was a legal right to the payments. So it's very difficult to see how they can be said to be an exercise of bounty, as it were, or gift.
I'm going to accelerate that up my list to about 70 seconds time now. Just to finish a list, once you've started a list, you really...
I'm on 2 at the moment.
Are you? You missed 3. 2 wasn't really a point, it was a definition of gratuitous. That's where I foxed you. 3 is that it almost inexorably follows from gratuity that payments are out of choice, spontaneous,
right, okay, fine,
and have the purpose of benefiting. Point 4 is there may be many motives for a gratuitous payment, gratuity being about the character of the payment. And they could be benevolence, they could be some commercial reasons, or they could be a mixture of the two. But if the payment's gratuitous, then these will all typically be motives for making a voluntary payment for the purpose of benefiting the claimant, and therefore something that's collateral, and indeed typically that would be thwarted by deduction of the payment from an indemnity, for reasons I'll explain, to the extent that that thwarting, which is a policy sort of an objective, is relevant. And so finally we say in almost all cases the payment is causatively independent or collateral where gratuitous, although you still need to look at the character and the purpose, and especially in state cases. Now, if I can just fast forward to what we say about the obligatory nature, and I'll come back to my course if I'm permitted. If we go to a case that was mentioned in the BDW case, and that's the Esso Bernicia. I may have pronounced that wrong. It's in the supplemental bundle, tab 2.
No, I think I remember the case. I think you've pronounced it correctly.
Okay. It's good to get one thing right. Tab 2, page 25. And It's a separate bundle filed a few days ago. It has, I think, six authorities in it. So tab 25, here we've got the case, it's the SO and against Hall-Russell case. And if you see from the head note, as some of you may recall, this was a negligence claim against the tug shipbuilder Hall-Russell as a result of a collision between an oil tanker and a jetty, which caused problems for lots of people, including an oil spill. So there's a negligence claim against the shipbuilder. And then if we just go to page 644 internal, which is page 26 in the bundle, just above the letter C, in the middle of that paragraph, there's a reference to all the different types of claim, and one of them was that there were losses, and it's next to the letter C, sums relating to payments made by them to crofters in respect of damage to sheep due to pollution of the foreshore. So SO has made payments to crofters. I understand crofter to be a Scottish tenant farmer, but I'm not certain.
I remember there was the allegation made against them was that these crofters were driving their sheep into the oil slicks.
I won't be drawn on that. And E and F below summarises the scheme called the Tovalop scheme, which includes the word voluntary, and explains what that was, which is the oil companies had, and not because of this spill, I think it was a pre-existing agreement, entered into a generalised agreement that they would make gratuitous compensation. I'll go forward to that as well. And if we go over the page to page 27 in the bundle, we'll just see Hell Note 3, which summarises the conclusion. And I think my Lord will see where I'm going with this, which is that having entered into the Tovalop agreement with other oil majors, etc., there was then an obligation to indemnify crofters who qualified for this, under the scheme. But nevertheless, as we'll see, the payments were found to be collateral. And if we go forward to page 48, so that's internal page 677, we can see Lord Jauncey at paragraph, going down, the paragraph that starts just above the letter G. So this is not a liability to pay compensation under statutory obligation that exists, essentially a tort cause of action. It was, in such an event, it would have been unavoidably imposed on them by a statute. So the statute was there and they would have had to pay. But here, the present case sentence starts 4 lines from the bottom. It's different. SO chose to enter into and remain a party of that scheme, no doubt for sound policy and commercial reasons, which probably included reputation and maybe the chance of avoiding a more stringent scheme being imposed upon them. That's not said there, that's just my gloss. And we see it's nevertheless it's gratuitous. That's over the page in the end of the first full sentence there. They were under no general duty in law to the crofters to set up the scheme. The scheme did provide obligations. And indeed, the flip side is noted. Having received payments, this is the other side of the case and not what they were actually ruling on, because this case was about whether SO could claim in relation to the payments that it had made out. Having received payments from SO, the crofters could have sued Hall-Russell, but arguing that what they'd received were no more than gratuities from a disaster fund, even though it was obligatory to pay them under the scheme. So we rely on this case partly because of the focus on gratuity. They were ex gratia payments, but whether they'd be called benevolence is to some extent by the by. They're obviously for a commercial motive that the scheme was set up.
But did the crofters have a legal right to the payment?
Well, that's my understanding.
How? What was the nature of the right?
Yes, I don't know.
This wasn't an agreement between a contractual right on the part of the crofter?
No, I think my lord's right. I think the obligation was inter se to the other oil.
Yes, I think so. So
yeah.
This is different from a case where you've got a legal right to the payment.
It's made clear at letter D on the page we're at.
Yeah.
In my view, they were made because ESSO has chosen, by entering into and remaining a party to the scheme, to assume a voluntary obligation to the crofters.
Yes. Well, that's right. It's voluntary as regards the crofters. Yes, they're obliged by remaining as a member of the scheme to compensate.
Yeah.
So the question is whether that makes a difference here. If you're focusing on the payor, which here is the ESSO, the point is that they did have an obligation, but that obligation, unlike a statutory obligation where they're under a legal compulsion, was an obligation that they had voluntarily assumed by joining the scheme, and that was obviously thought to be causatively significant here. So the voluntary action was embarking upon the scheme. It just so happened that the nature of a disaster or oil spills is that they're of such a scale and, in this case, frequency, that it's worth having a generalised scheme. And so having set up the scheme, you then have committed yourself to making payments. But we say the same is true of the furlough scheme. This was not a pre-existing scheme of social security. It was a scheme set up in response to the pandemic. It's a disaster fund. And the mechanism, by virtue of the fact that the pandemic was countrywide, obviously global, but for UK purposes was countrywide, the mechanism was to set up a scheme by which once the scheme's set up, you can just, as an administrative action, apply and get your payments. Obviously, it wouldn't have served its purpose if you'd said, well, we keep a discretion and you're going to have every case will be considered by somebody. That would have taken a lot more than 10 days. But the voluntary action is setting up the scheme, and that's, as was here, and that's the action that is spontaneous, abnormal, and voluntary. And the fact that having done so you have to follow through doesn't make the payment any less voluntary. In the same way that if, in the Castellane example of the brother, if the brother had said, I can see you've got a problem because your property's just burnt down. What I'm going to do, and this is, I know this might help you also when you go and take out a loan, I'm going to enter into a deed that says I'm going to pay you £1,000 every month to keep you going in return for nothing because I'm your brother. The fact that you've committed to a contract that makes it obligatory to make those payments is completely irrelevant because the voluntary action is in setting that up. So the mechanism of the contract may postdate the voluntariness, but doesn't eliminate it. It's just the mechanism. If ever a payment's going to be in the future, then you may end up embarking upon an obligatory scheme. So, my lord, that's what we say about that. And we say that is an answer. And if we could go back to where we were, and it's also in the same...
That would mean that
yes,
every contract falls within your voluntariness idea.
well, a gratuitous contract, but the contract's still gratuitous. What I'm saying is that it doesn't become compulsion in a causatively relevant sense, where you impose the compulsion on yourself, effectively. It still has to be a gratuitous contract. If I'm promising to buy your vessel, that we're not even in the territory.
For that reason.
For that reason.
Yeah.
But the executory obligation aspect doesn't change anything, because you've imposed the compulsion on yourself as a voluntary choice, just like the brother who decides to make the deed. So another disaster fund case, this is at page 1808. Or is it, sorry, in the main bundle, 1808. This is the Redpath case. And it's a first instance decision, but it's one of the heavily cited cases in all the social security cases. And in fact, it's the source of the revolting to the sense of the donor quotation in Harry and Cleaver that is oft repeated. If we look at 1809 at the bottom paragraph, you can see briefly, you can see what the facts were. There was the mayor of Bangor set up a disaster fund for the victims who were mainly from Bangor, and private individuals paid into that scheme. And then at 1810, at the bottom paragraph, in support of his argument, there's the familiar argument that, oh, the claimant will double recover. This goes over the page. And that's then rejected at the middle of bundle page 1811. And it includes the startling to subscribers if they were told their contributions were really made for the benefit of the negligent railway company. And the further reasoning is at 1813, towards the bottom of the page, under the admittedly paragraph. You'll see a couple of sentences in begins, the important consideration to my mind. And it's that the setting up of this disaster fund and the subscriptions to it arose independently of the cause of action. While admittedly a sequence, it was not a consequence. Novus actus interveniens, not the outcome of the relations between them. That's what happens when you have a third party giving a gratuitous payment. And if we see over the page, the causa causans was not the accident, but the bounty or charitable motives of the subscribers. And that's what broke the chain of causation. So we say, putting those two cases together, a gratuitous payment will break the chain of causation. And if one wants to adopt, and I'll look at it in a second, the Hart and Honoré explanation, it's because of its voluntariness. It could also be for policy reasons, which happily coincide. But it's voluntary, it's also spontaneous reaction and abnormal because it's gratuitous. Things for value are not abnormal, they're the normal relations between commercial parties and are very unlikely to break the chain, unless there's some gratuitous additional aspect. But here we're dealing with gratuity. We're already in the territory of breaking the chain or being collateral. And if we just briefly look at it in Hart and Honoré, this is in it's in the supplemental bundle because the extracts in the main bundle were a bit abridged. So in the supplemental bundle, tab 6, paragraph, page 105, this is Hart and Honoré, who need no introduction, and towards the bottom there's the heading factors negative in causal connection. And they explain, a little bit like Professor Bartlett in the second sentence, that they identify voluntary human action and abnormal occurrences under separate heads. That's the two Hart and Honoré categories. Abnormal occurrences is roughly equivalent to Professor Burroughs' directness. And the voluntary human action covers much of the ground of Professor Burroughs' further category. And at the top, that's where they make the point that directness doesn't really explain things for voluntary payments. At the bottom, so at the bottom of page 106 of the bundle, you see they have a heading voluntary human conduct, and they describe how that breaks the chain. And then at the foot of 107, you'll see Roman 3. They say, well, this is true of the voluntary human conduct which negatives the causal connection, not only with a loss but also with a gain. And then at 111, we see, and I think this is quoted in our written case, Roman 3, they talk about gain. It's a compressed discussion, but they include gains that are a result of the voluntary action of the third party as being collateral, and they cite the cases up to that date, which include the Espan case at footnote 54. Yeah, national insurance in Espan. So that's the voluntariness explanation, which we've already seen resonates in some of the case law. We refer to that in our written case. I'd like now to turn to an insurance case, the B Atlantic, which is at page 980 of the main bundle. So this is a judgment of Mr. Justice Flo.
Before we go there,
yes.
So I'm getting two sort of concepts coming through: voluntariness and gratuitous actions. You're effectively aligning them, are you not, for these purposes? I mean, you're saying that the wider concept is voluntariness, but a form of it is gift making, as I understand.
Correct, my lord.
Yeah.
Obviously, voluntariness for heart and honour includes the felonious third party who's committing a crime and doing something that therefore counts as voluntary. But we're in the territory of gratuitous. We're saying gratuitous payments will almost always qualify by virtue of voluntariness, if not also by virtue of policy protections for gratuity, and indeed abnormality, which perhaps slides into voluntariness. So briefly on the B Atlantic case, this was Mr. Justice Flo as was. Very brief reasoning here, but we say he got it exactly right. The claimants were the owners of an insured vessel, the B Atlantic. The vessel was detained, triggering the war risks cover. And you can see the clause at that page, page 980, on the right-hand side, it's clause 13, a suing and labouring clause. And under 13.2, the underwriters will contribute to charges properly and reasonably incurred. And the owners sought to recover their suing and labour costs. You can see from page 99990 of the bundle, paragraph 346, the first sentence explains there's 1.4 million of such costs, and the second sentence explains that they were to help get the vessel released and defend the crew as well. So there's a dual purpose, and there's a dual purpose argument as to whether that is a problem, and the answer is no, but that's not our issue. Our issue is introduced at 347 at the bottom, which is 1.2 million of the overall total was funded by Guards, the P&I Club, on an ex gratia basis. Ex gratia because it fell outside the cover. And in that paragraph, it's also confirmed Guard did not expect reimbursement, so it wasn't a loan, it was a gift. And the conciseness is help here, particularly at this time before lunch. If you see paragraph 348, all of the reasoning is in that paragraph. So why was it collateral? It was held to be res inter alis acta and relying on merit because it was voluntary and therefore does not diminish loss, and so you disregard it. Now, the points to take from this case, with respect, my lords, we say this is right. We say, first, and this actually is a ground one point, there was no argument here that the sue and labour costs had been reduced, had not been incurred by virtue of the fact that they'd been paid for by somebody else. Now, the insurers may say, oh, well, they missed a trick there. But we say it's obviously right that the costs were still incurred, even though 1.2 million of them as a matter of economic reality, if you like, were defrayed by the P&I club. Now, it's not exactly the same word, it's the word incurred, but we've already seen equivalents of the word incurred to our wording of payable in Mobis and Glyn and elsewhere, and in the Treasury direction. So that's a ground 1 point. But on the ground 2A, we say, firstly, you can see that Mr. Justice Flo saw voluntariness as the key. So the voluntariness arose here because it was ex gratia, but he didn't feel the need to identify the motive of guard, which was no doubt not purely charitable. It's a P&I club that only has its limited funds from subscribers, but it obviously was partly commercial, maybe reputation, or to support the future business of one of its customers. And we don't need to go there, but the Colin Vaux textbook cites this case as one of the cases for the proposition that a commercial motive doesn't stop a payment being collateral, which is obviously right here. The other point to note is that this payment was specifically hypothecated to the expense, as in our case. This isn't a general fund that you're taking into account. This is somebody has paid the actual fees. And nevertheless, we say rightly that didn't make any difference, because you still have to ask what's the purpose and character of the payment. And so it's said here that it therefore does not diminish the reinsured's loss. We agree that talking about diminishing a loss doesn't really help you. That's the conclusion. So therefore, it's fine to say therefore. That's the same as saying therefore was not legally caused or therefore is collateral. But it's no help to say, well, the expenses were gone, so the loss is diminished. That we have to look at the gratuity and the voluntariness.
I mean, here we're going to have to look at the nature of the scheme, aren't we? And
we are.
The question is whether it's reasonable to characterise it as a form of charity or bounty or that sort of thing on the part of the government, or whether that isn't really a fair characterisation of a form of
My Lord, yes.
state insurance, if you like. It's almost like another form of business interruption insurance that the state is providing. The only difference being you're not paying for it.
Well, so we say, but you don't start with benevolence, you start with gratuity, and the payment is gratuitous, and so the motive obviously is partly to benefit, we're going to come to this, but it's partly to benefit the payee and partly for economic reasons, and therefore it satisfies because it's voluntary, unusual, spontaneous, responsive, abnormal, etc. And those are the reasons why it's collateral. And my Lord says, well, it's a bit like a scheme where you haven't paid into it. One can see that, but that doesn't remove the fact that it's therefore gratuitous. So although it may not satisfy, we don't rely on the taxpayer idea that anything from the state is subscribed by you and therefore is equivalent to insurance. But that's a separate category that we're not in. We're in the category of a gratuitous payment by virtue of the fact that you haven't paid for it. So, my Lord, if that's a convenient moment.
Yes, certainly, Mr. Kramer. We'll adjourn now and resume at 2 o'clock.